The right to peacefully assemble and protest is protected by the First Amendment. Generation after generation have used this power of dissent to right wrongs and push people in power to do the right thing for America's promise of equality. In 2020, more than 26 million people took to the streets to support the Black Lives Matter movement and its campaign to end police brutality. Fresh in their minds were the murders of George Floyd, Ahmaud Arbery, Breonna Taylor, Rayshard Brooks, Tony McDade, and so many others. The overwhelming majority of those protests were peaceful, and yet in many towns across the country, police responses ranged from militarization to brutalization. People calling for an end to police brutality were met with tear gas, rubber bullets, and handcuffs. Governor DeSantis and his allies in the legislature responded to the Black Lives Matter movement with bills designed to criminalize protests. The legislation gives police more ways to arrest peaceful protesters and protects Confederate monuments, exposing anyone who pulls down such shrines to white supremacy up to 15 years in prison. The legislation gives counter-protesters a way to avoid even civil liability for injuring, or worse, killing others. This legislation also gives Governor DeSantis complete power to override a city's decision on local police budget matters. Under the DeSantis legislation, anyone participating peacefully in a gathering can be charged with a felony if others, even counter-protesters, are accused of an illegal act. Given Florida's horrendous legacy of racially discriminatory justice, this new law is sure to be used disproportionately against Black protesters. We cannot allow our government to silence voices it doesn't agree with. Criminalizing dissent is a dangerous violation of our constitutional rights. It is anti-democratic and un-American. That's why we're suing to protect Floridians' First Amendment rights.